Then case item 19 WPL 236 of 2018.
Who's the respondent?
So our contention was that we had paid the gratuity amount, but we could not submit
Account for it.
33,139.
Submit the
But we could not produce the proof, as a result of which the controlling authority decided the matter against us. Subsequently, all this development has taken place. Once we figured this, and ultimately it reaches the for review, and the review is rejected on the ground that he doesn't have the power. So these are the facts. I know we brought these facts to the notice of the authorities, controlling authority, first time on 7/11/2015 by Annexure 4. That is how it has gone. 2014 is the date of the year when the application was filed. 28th of May 2014, the controlling authority passes an order on 5th December 2014. Then we move an application to the authority on 7/11/2015 by Annexure 4. After we have collected all these documents which show that payments have been made towards gratuity. That is all. And the amount is paid towards gratuity is reflected from our gratuity payment register that I have filed along with my supplementary affidavit at page 9, where the name of the employee figures at serial number 960. Second from the bottom, and it reflects the account number, check number. Otherwise, at the top, it mentions against that amounts column gratuity, GITY, that is how they write it. And I have the register in original relating to gratuity, which shows that the amount is paid towards gratuity.
As per the order passed by the controlling authority, what is the exact amount of gratuity? It is again 33,000 something.
Yes, the amount.
Quantified.
Quantified amount is at page 27.
This is total gratuity amount.
This is gratuity amount.
So you want a deduction against this amount?
Yes, 170 is the deduction towards that. The total amount awarded for payment is 1,95,702, to which we have submitted to the authority that we have paid this amount 33,139.80 towards gratuity.
So out of this total amount, according to you, 33,139 was to be deducted.
Deducted. And that is my
and
prayer.
And the remaining was payable?
Was payable. And that is what my prayer in the writ petition is also. Kindly see the prayer. for issuance of a so-and-so pass vessel, by which the petitioner has been directed to pay the gratuity amounting to rupees so-and-so, although an amount of rupees 33,139 towards gratuity had already been paid, and therefore needs to be settled. This is the prayer.
Yes, what do you have to say?
Lord, with the limited no observation of playing. Page number 33, they are seeing that check amount of rupees 2,59,000 is ready, my lord. So they are prepared the check and to be paid to the opposite party number 3. If they are willing to pay and they are prepared the check with the intent to make the payment of gratuity, they will issue form L and annex the check amount in favor of the opposite party number 3. Because if they are showing that the check is ready and it is prepared and the amount is shown at 2,59,000 such and such, they will also issue form L for the payment of gratuity as their statute says. Rule 8 says, within 15 days of receipt of the application under Rule 7 for payment of gratuity, the employer shall, if the claim is found admissible on verification, issue a notice in form L. So they have prepared the check, they are saying that check is ready, my lord. Only thing that is remaining, that issuance of form F. If they will issue, my lord, I will receive the amount. Because my lord, opposite party number 3 has died. Check is ready, my lord. If they will issue form F, it will be paid to the opposite party.
Thank you. WPA number 236 of 2018. For the Council for the Parties. This petition has been filed for the following reason. The records of the case reveal that the ex-employee who was respondent number 3 expired during the pendency of this case, and he was substituted by the present respondent number 3. The learned counsel for the petitioner submits that the order of the controlling authority and the Payment of Gratuity Act 1972, dated 5th of December 2014, within bracket generation 2, is under challenge in the present proceedings, only to the extent that the amount of rupees 33,139, which was paid to the ex-employee, is required to be adjusted. The learned counsel submits that at the time of adjudication of the said case, the proof of the payment of rupees 33,139.80 towards gratuity could not be substantiated by any documentary evidence, and therefore such payment was disbelieved by the authority, and the total amount of gratuity was quantified at rupees 1,95,702 without adjusting the amount of rupees 33,139.80 paid. He submits that subsequently the petitioner has obtained a certificate from the petitioner applied for information from the branch manager of Allahabad Bank by letter dated 26/10/2015, who has certified that an amount of rupees 32,969 containing check number 44441134 dated 2/7/2009 was credited in the account of the ex-employee after deducting rupees 170, and the total amount it was credited was to the extent of 32,969. He submits that the said amount was on account of gratuity. He has further submitted that a supplementary affidavit has been filed in the present case, bringing on record the register maintained by the petitioner with respect to the various employees regarding payment of gratuity and the name of the ex-employee is found that
Serial number 960.
it is that document
Supplementary affidavit dated 8/8/19, page 9.
8 is found at page number 9 of the supplementary affidavit dated 8/8/2019, giving the details of the check number and the gratuity amount of rupees 33,139. It is a statutory register.
Statute does not provide for any register.
The learned counsel submits that after receiving the document from
It's
the
a
bank,
gratuity register. There is no statutory form, but it is a gratuity. It has a heading.
the learned counsel submits that after receiving the aforesaid document from the bank, they approached the controlling authority seeking a review of the order to the extent of adjustment of the amount of fees 33,159 against the gratuity already paid, and to pass appropriate order, but the said authority wide order dated 29th of May 2017 has refused to entertain the petition by observing that there is no power of review. The learned counsel submits that. Thereafter, the writ petition was filed on 12/1/2018. He has submitted that the entitlement of gratuity is not under challenge, but the amount of gratuity already paid to the extent of rupees 33,139.80 to the ex-employee is sought to be adjusted by virtue of the present writ petition. The learned counsel appearing on behalf of the respondent, private respondent, has submitted that the amount that a rejoinder to the supplementary affidavit dated 8/8/2019 has been filed, mentioning that the said amount of rupees 33,139 was paid in connection with the revised basic wage rates for piece-rated workmen, and the payment was not on account of gratuity. यही है ना आपका केस?
Yes, madam.
The Learned Counsel has submitted that the document in connection with bank only refers to transfer of the amount and no heading for such transfer has been mentioned. He has further submitted that the gratuity register which has been, a copy of the gratuity register which has been filed before this court by way of supplementary affidavit was always available with the petitioner, but there is no explanation for not submitting the same before the authority. The Learned Counsel submits that it is a disputed fact as to whether the amount of rupees 33,139 which is claimed to have been credited on account of the ex-employee was on account of gratuity or under some other head, as claimed by the petitioner and disputed by finding the contract. The Learned Counsel has also submitted that the order of the controlling authority was passed on 5th of December 2014 and the petition seeking review, though it was not maintainable, was filed on, when did they file it? On 7/11/2015. That is more than after expiry of more than 1 year from the order passed by the controlling authority, and the same has been rightly declined as the review is not maintainable. The Learned Counsel has also submitted that even the appeal against the order of the controlling authority had become time barred by that point of time, and there is strict timeline of maximum period of 120 days for filing an appeal. The Learned Counsel submits that the impugned order passed by the controlling authority may not be entertained, may not be set aside in the writ jurisdiction. He has also submitted that the petitioner had also prepared a check for payment of the amount as contained in annexure
7, madam, page number 33.
at page number 33 of the writ petition. The check is contained at page number 31, but the same has, but necessary formalities having not been done, the ex-employee could not receive the said payment and ultimately he has expired. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case,
One
this
thing
court
also, they are saying that, although madam, they are saying that 33,000 has been paid on the head of gratuity. In that case also, madam, there is no form L.
the Learned Counsel has also submitted that the payment of gratuity amounting to rupees 33,139
If at all, madam,
has not been included in form L, and therefore in the statutory form L maintained under Rule 8
yes,
of payment of gratuity within bracket Central Rules 1972, and therefore the said amount cannot be said to be a payment against gratuity. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court finds that a proceeding for payment of gratuity was initiated by the ex-employee on 28/5/2014, and after giving due opportunity to the concerned parties, the total amount was quantified at rupees 1,95,700. Although the petitioner had claimed that an amount of rupees 33,139.80 was paid towards gratuity to the applicant, but no documentary proof was filed to that effect, and consequently the said amount was not attested, and a direction was issued to pay an amount of rupees 1,95,702.00 with interest at the rate of 5%. It further appears from the record that the petitioner, much after expiry of the order passed by the controlling authority, approached the Allahabad Bank by letter dated 26/10/2015 and took a certificate that an amount of rupees 33,139 was credited in the account of the petitioner of the ex-employee through check number 441134 dated 2/7/2009, and while crediting the amount, an amount of rupees 170 was deducted on account of bank charges, and consequently the net credited amount was only rupees 32,969. The statement of account has been annexed along with the petition, stating that the same was by way of transfer. The statement of account does not reflect under which head the amount was credited. This court further finds that the petitioner has filed a supplementary affidavit trying to bring on record the so-called register regarding payment of gratuity for the first time in writ proceedings, although no such document was produced by the petitioner before the authority when the petitioner filed a petition seeking review of the order passed by the controlling authority. The respondent number 3 has vehemently opposed the prayer of the petitioner, stand of the petitioner that the amount of rupees 33,139, the amount credited in the bank account to the extent of rupees 32,969 was on account of gratuity. Rather, the respondent number 3 has claimed that the same was on account of payment due to the ex-employee under a different head. This court finds that there is no explanation on the part of the petitioner as to why they did not produce the so-called gratuity register before the controlling authority and have tried to substantiate their claim for the first time before this court by way of filing the supplementary affidavit. the fact remains that there is serious dispute in connection with the credit made in the account of the ex-employee to the extent of rupees 32,969. In view of the aforesaid facts and circumstances, this court is not inclined to interfere with the appeal order passed by the authority under the Payment of Gratuity Act and in writ jurisdiction. Accordingly, the present petition is hereby dismissed. Just a moment. The reply filed by the petitioner to the supplementary affidavit filed by the reply filed by the respondent number 3 to the supplementary affidavit filed by the writ petitioners has not been controverted by filing a rejoinder. उसका कोई rejoinder तो नहीं फाइल किया?
Kasura case item 16. 13. Item 13, Kasura case WPC 1608 of 2017.
In this case, the challenge before you receive is annexure 4, page 23, whereby that is order dated 28/1/2017, whereby not the circle officer having no jurisdiction under the LA Act or even under the new Act decided the intercede dispute between the two groups, two parties, that is the petitioner in one end and another respondent number 6 and 7. If you also may have a glance over annexure 4, page 23. It relates to the payment of compensation dispute with regard to the apportionment of.
This is an inspection report or not?
Yes, ma'am. It is an inspection.
This is an inspection report.
Your Lordship may kindly see.
Annexure 4.
Annexure 4 it is not an inspection report.
सुस्पष्ट जांच प्रतिवेदन
That is not the report and decided in the garb of it. It is not headed. The heading is there. Page 23. Your Lordship may kindly see. Your Lordship is correct. That Bhavadiya Karja, that is with reference to the matter, was referred by the district land acquisition officer to the circle officer for having a report. That is सुस्पष्ट जांच प्रतिवेदन उपलब्ध कराने के संबंध भवदीय कार्यालय पत्रांक सचन सच भूअर्जन दिनांक 28/12/16. देन मिलॉर्ड योर लॉर्डशिप विल फाइंड कि प्रतिवेदन की मांग की गई। इस संबंध में अधोस्ताचरी कार्यालय द्वारा दोनों पक्षकारों को नोटिस दिए, अपने दावों का संबंध में पक्ष रखने का मौका दिया। अल्टीमेटली मिलॉर्ड योर लॉर्डशिप में काइंडली कम टू पेज 25 ऑनवर्ड्स। 25 मिनट तिलोकी प्रसाद सिंह, the respondent number 6 and 7. 5. तिलोकी प्रसाद सिंह की ओर से सर्वे खतियन सचनसा प्राप्त कच्चा पर्चा को दिशाएगा भूमि का खाता फतू सिंह और महेश सिंह पिता सचनसा का दर्ज किया गया। पार्टीशन सूट नंबर सचनसा गणेश सिंह वर्सेस फतू सिंह के नाम से बाद में गणेश सिंह की ओर से पैरवी के अभाव से खारिज कर दिया गया। यह टाइटल पार्टीशन सूट नंबर सचनसा बंदोबस्त प्राधिकारी भूमिका के पारित तिलोकी प्रसाद सिंह की ओर से 15/1/36 एक गोदनामा दाखिल किया गया, जिसमें रमन मेहरा ने फतू सिंह को गोद लिया, जिसमें जिक्र हुआ कि कोई वारिस नहीं होने के कारण फतू सिंह को गोद लिए अनुमंडल पदाधिकारी दिनांक गुड्डा के म्यूटेशन केस नंबर सचनसा एवरीथिंग इन डिटेल मिनट। देन अल्टीमेट फाइंडिंग इन लॉसी में काइंडली सी दिस पेज 26 मिनट पेन अल्टीमेट पैराग्राफ। माधुरी सिंह वगैरह द्वारा किसी भी प्रकार का कागजात या दावा के आधार पर संबंध में कोई कागजात प्रस्तुत नहीं किया गया। ये रमन मेहरा के सही वंशज हैं। इसी प्रकार रमावती देवी द्वारा जमाबंदी सिंह का 53 केवल पर्चा दिया गया। उनके द्वारा जिस प्लॉट पर दावा किया जा रहा है उस प्लॉट का अधिग्रहण ही नहीं हो रहा। सबसे बड़ी बात है, अधिग्रहण होने जा रहा है प्लॉट नंबर दाग म्यूटेशन प्रथम पक्ष द्वारा बात सिंह का इतना में ही करा लिया गया है। उसके दावे के समर्थन मजबूत आधार है। साथ ही तिलोकी प्रसाद सिंह को बाधगत जमीन दखल और कब्जा भी है। इस तरह आपत्तिकर्ता का दावा भी भू अर्जित भूमि पर उचित प्रतीत नहीं होता। अतः आपत्तिकर्ता का दावा पूर्ण खारिज करने योग्य है और भू अर्जन कार्यालय द्वारा जो हितबद्ध त्रिलोकी प्रसाद सिंह के नाम का जो अवार्ड बना है वो सही है। नाउ your lordship may kindly see annexure 1. Annexure 1 is the notification, the page 16. It relates to the old Act 1894. Your lordship may kindly see top of it, of the
Yes.
same mirror. भू अर्जन केस संख्या डैश of 2013-14 ली जाने वाली जमीन के लिए एक्ट 1 of 1894 के धारा 9, that is objection was invited, and accordingly the objections were raised by the present petitioner and their other co-sharers. That is annexure 3, annexure 2 and 3. Then annexure 2. Annexure 2 is the objection raised by the petitioner.
Let us see your objection.
Annexure 2.
You claim to be the, you see there is,
I claim to be the person who are interested person to have the apportionment in the compensation. And whereas the respondent number 5 also claimed to be the in whose favor the award was prepared. Now the
respondent
law
number
says
5 claims to be the descendant of the Rayyan.
Rayata. We are also the descendants of the Rayata. That
Who is the common ancestor? Who is the recorded tenant
that
as
we
per
have
Annexure 2?
already given blood that
Who is the recorded tenant as
Page-
per Annexure 2?
yes, page 21 we have given the genealogy.
Page 20.
Yes, page 21.
20
In our
में है
objection,
genealogy.
we have given the genealogy also.
Yes, who is the recorded
Yes,
tenant?
recorded tenant is Raman Mehra, in whose name the land was recorded. Raman Mehra.
Naman.
Raman, R-A-M-A-N.
That is
has
at
been-
page number 20.
Yes, page 20.
Yes.
Page 20, I am sorry. Page Raman Mehra.
Yes.
Now, my lord, Raman Mehra, according to the respondent 5, he died issueless, whereas in our case, he died leaving behind a daughter, Mohammad Jogni, and that is the dispute. And that dispute can only be decided under section 30 of the Act. If you lordship may kindly see the section 30,
Yes, so why have you come for the repetition?
because of this report, my lord, although it is a report, in the shape of a report, he practically adjudicated our right, title, interest and the claim, interclaim between the parties, which cannot be done under the Act. And if the award is prepared, that if any dispute is raised before the collector, instead of sending it for a report to the circle officer, he could have referred the matter to the district land acquisition judge. That is the law. Under section 30, if you lordship may kindly see for a moment. When the objection was raised by the petitioner, it was incumbent upon the respondent number 3, who is the district land acquisition officer, to act within the four corners of section 30 of the Act. There are two types of objection. One relates to the amount of compensation, area of land, that is section 18. And section 30 is not particularly, if you lordship may
Land
kindly permit me to refer. Land acquisition of Purana. 1894. This book is. Yes. Section 30.
Yes, dispute
Yeah.
as to apportionment.
Dispute as to apportionment. When the amount of compensation has been settled under section 11, meaning thereby award is prepared. If any dispute arises as to the apportionment of the same or any part thereof, or as to the persons to whom the same or any part thereof is payable, the collector, meaning thereby the district land acquisition officer, may refer such dispute to the decision of the court. Court means the district land acquisition judge. This is the only duty given to the district land acquisition officer. Instead of doing so, he called for a report from circle officer.
Let us see what objection did you raise.
Yes, if you lordship may kindly see annexure 2.
Election. Yes. You are saying that it has been wrongly entered in somebody else's name.
Next, respondent 5.
Yes, you are
Yes.
disputing the entry of the recorded Rayat itself.
No.
Yes.
I am disputing the award. Your Lordship, just see.
You just see,
This
you read it
is a-
Mahashay.
Yes. Jila Bhuvarjan Padhikari. It is addressed to the respondent number 3.
Yes.
Who is the collector under the act?
Yes.
विषय मोजा सचन सच के अधिग्रहण के गलत हितबद्ध रैयत का नाम मीनिंग दे इंटरेस्टेड रैयत नेम रॉन्ग एंट्री दर्ज करने एवं अधूरा हितबद्ध रैयत का नाम दर्ज करने के संबंध में दिस इज विषय अंतर्गत जमीन अधिग्रहण हेतु प्रपत्र फॉर्म के अवलोकन के पश्चात ज्ञात हुआ कि खाता नंबर 53 की मिली भगत से गलत वंशावली बनाकर गलत व्यक्ति के हितबद्ध रैयत इंटरेस्टेड पर्सन दी वर्ड यूज नॉट इज इंटरेस्टेड पर्सन अपना नाम दर्ज कराकर मुआवजा राशि हड़पने का षड्यंत्र किए हैं। खाता संख्या 53 के सही वंशावली निम्न प्रकार है। रमन मेहरा he has said that he died issueless, but according to us he left behind one daughter Muhammad Jagni. Muhammad Jagni had 2 sons Chamru and Ganesh. We are the legal heirs of Chamru. Adhiklal Singh, Sukhlal Singh was the original writ petitioner. He died not, and therefore he has been substituted by 2 legal heirs. And Jaikant Singh, they are the 3 brothers. And the others are Ganesh Singh. He also died, leaving behind 2 sons, Madhuri Singh and Dhanusdari Singh.
You see, after the death of Raman Singh,
Raman Mehra,
the entries were already made in the record of rights.
But still, my lord, it is to be now. It is for the court to decide. The collector becomes functus officio. He has been simply given a duty to refer it to the dispute is to be referred. Now the fact remains that we have raised a dispute, and that dispute is before the collector. Now what was to be done under the act?
Were you in possession of the property?
We are, according to us, we are in possession. According to him, he is in possession. All these things are to be decided after leading evidence before the court of law. And court of law is the district land acquisition judge, as per section 30. Land acquisition officer has no authority to refer it or to have a report from circle officer who has no role to play in the entire land acquisition act. So, in our submission, in my submission, the annexure 4 is without jurisdiction. Even it is in the shape of a report unit. He failed to refer the matter.
Then pursuant to this report, what order was passed?
No order was passed. Our objection was overruled. It
Where is
cannot
the
be.
order?
That is that he submitted the report and the counter affidavit also silent.
So
That is
I have submitted one counter affidavit.
Just a
on behalf
moment, please hold on.
Yes.
Yes.
the
This was just a report.
report.
Thereafter,
Therefore,
one
district-
order must have been drawn.
The award already when the award was prepared in the name of respondent 5, to raise objection, and that objection before the collector. Now, as per law, it was to be referred when there is a dispute, any sort of dispute. That dispute is to be decided and adjudicated by the district land acquisition officer. Instead of him, it will not he call for a report from circle officer. Upon receipt of the report, if your lordship may kindly see the counter affidavit is silent about it. Nothing has been brought on record. The counter affidavit dated most probably will not, this is on behalf of all, even on behalf of the private respondent.
The amount has been disbursed in favor of private respondent.
Even then will not, if after adjudication, I do not know. That is silent.
The amount has been disbursed in favor of private
Yes,
respondent.
till the filing of the counter affidavit, I had no information, but it has been disbursed.
Nothing has been stated in the
No,
council.
the final order is already there
No,
on the
my,
record.
my counter is silent on this one.
Whether it is disbursed or not.
Yes.
Let's,
You are silent. You are silent spectator to everything. Things which you have not stated in the counter affidavit, please don't say. We are not bothered about it. You are talking about adoption deed. So where do you get this?
Whereas my submission is that the challenge to the order of the circle officer and the order passed by the circle officer does not in any manner change the award in question. Award is already prepared, my lord.
That's right.
And as per the judgment of this Supreme Court, my lord, there cannot be interference in the award
That's
from
right.
any perspective from our
They are
side.
not challenging the award.
Yes, so they are simply, Manas, at least they are saying that as per the genealogical table, not the respondent number 5, there should also be the
Co-sharer, whatever.
beneficiary. Even that cannot be amended by us in the award. For that purpose, they have to move before the land acquisition officer
Under which provision?
under section 30 of the
30.
land acquisition act.
They'll have to file an application under
For the
section 30
of the land acquisition act
to refer the dispute to
to the appropriate authority judge.
merely by questioning that they have a share is not sufficient.
We are not the authority to adjudicate all these things. It can be adjudicated with the help of
Who is the
evidence.
authority? Respondent number?
3.
They filed
Before
the
whom
petition
I
before
filed the
respondent
objection.
number 3 only.
Yes.
Yes.
They filed their petition before respondent
Yes.
number 3
Yes.
only,
Yes.
but no prayer as such was made to refer the dispute under section 30.
But we have raised our objection.
You
No.
have raised it.
Now, if they make an application of fresh matters, we shall consider this because the law says.
You want your adjudication under section
It
30?
should be adjudicated by the district land acquisition officer. It should be referred by.
It has already been
He
adjudicated,
has
my
to
lords.
refer.
You see,
No reference has been made. Who has decided?
Lords, may I assist your lords for a moment? If your lords allows me. So, section 11 may kindly receive.
just a moment. Mr. Sani, in your petition you say that the name of the Rayyat in the
Yes.
record of right should be rectified.
Yes.
Right?
No.
This is your prayer in your petition.
My
You just
prayer
have a look at it. Read it, please.
That is not.
Read it, please read it.
Yes. अतः श्रीमान से प्रार्थना है कि हितबद्ध रैयत यानी इंटरेस्टेड पर्सन एज पर द लैंड एक्विजिशन एक्ट भूमि सूची में दर्ज गलत व्यक्ति का नाम हटाकर दैट इज इन रिलेशन टू द अवार्ड जमाबंदी रैयत रमन मेहरा के उत्तराधिकारी का नाम वंशावली के आधार पर दर्ज करने की कृपा करेंगे ताकि गलत व्यक्ति मुआवजा का राशि हड़पने न पाए इट entire thing with regard to award. The award was prepared in the name of a wrong person, and that is the law provided. If section 11 award is prepared, then only section 18 or section 30 comes. The role of section.
But after the report of the circle officer, there
Yes.
is no fresh order
So therefore, it was the
rejecting your objection
Nothing.
or allowing your
or
objection.
adjudicating. He can't adjudicate.
He has to, you see, once if he calls for a report from the circle
Yes.
officer, he has to either accept it
He-
or reject it.
Therefore, my submission is that nothing has been done. It should have been. He has no other alternative except to refer the dispute to the district land acquisition officer. That is section 30.
Just, हाँ, बताइए क्या बोल रहे हैं?
Lords, may kindly peruse annexure A of my counter affidavit. What your lordships is asking, that is there, my lords.
Annexure A of your counter affidavit?
Yes, my lords. Respondent number 5. When they made an objection, the matter was referred for inquiry. That is under section 11, my lord. My lords will kindly see annexure 11 gives the power to the collector to get into an inquiry so that a fair award could be prepared. Now, my lords, annexure A.
When did you file your affidavit?
Staff right,
Annexure A, yes, I have got that. This is the last affidavit, 31024. 31024. Where is the final order passed by the land?
Lords, yes, my lords. 3 orders, my lords, on 3 different dates have been passed. Finally, it has been decided in favor of the respondent number 5, and it has been ordered that the payment be made to him. Now, my lords, one question that
Where is that order? Read it.
I'll read the entire one.
No, not at least that payment should be made.
Page 15. Oh, page 16. Sorry.
Page 16.
16.
Yes. After hearing them,
let's दोनों पक्षों को सुना गया है, that is there in the order, because this proceeding was going before the land acquisition officer. So land acquisition officer, when they made an objection, he asked for an inquiry of the facts. Now, on the facts also, my case is strong because I have provided documents in support of my claim. Now, even in the repetition, they have not provided any document. The genealogical table that they are relying upon is their own document. That is their handmade document. That is not an authoritative document in any way. Now, my lords, page 16. उभय पक्ष द्वारा अपना दावा किया गया, जयकांत सो एंड सो, अंचल अधिकारी सो एंड सो द्वारा प्रतिवेदित किया गया. तो अंचल अधिकारी का रिपोर्ट इज देयर. पूर्व में अंचल अधिकारी सो एंड सो हितबद्ध व्यक्ति की सूची में त्रिलोकी के नाम से प्रतिवेदित किया गया. दैट इज इन फेवर ऑफ रिस्पोंडेंट नंबर 5. लेट्स गॉट इट. पुनः अंचल अधिकारी गोड्डा के सो एंड सो द्वारा प्रतिवेदित किया गया कि भूमि पर खतियानी रैयत का पोता त्रिलोकी प्रसाद सिंह है, वो अपने दादा के संपत्ति का दखलकार है. Now this is the inspection report, ground inspection report. दादा के चचेरे भाई रमन महरा के नावल्द हो जाने के कारण फतू सिंह को गोद लिए जाने के बाद रमन महरा की भूमि का उत्तराधिकारी त्रिलोकी सिंह है एवं खतियानी रैयत है. आज के समय में आई एम द खतियानी रैयत also.
On the basis of some adoption deed.
Adoption deed, thereafter mutation है.
सादा adoption.
बीच में बोले तो कैसे हम ठीक है. उसके बाद म्यूटेशन भी है मेरे फेवर में. ऐसा नहीं है this is only one document that was fallen from some place. There are subsequent documents in my favor. Title suits भी हुए हैं, adjudicate हुए हैं. These are all.
Title suit about what?
Let's. I will just read, my lords.
No. That is just figured out. You are claiming some right by virtue of adoption deed.
Yes, sir.
And that adoption deed was a matter of adjudication in a suit in which they were party. आज सिर्फ इतना सा बात बताइए.
Let's. May I say only one thing, lords. उसके पहले हम एक और बता रहे थे. Earlier also there was an acquisition for Nahar. नहर वाले acquisition में फतू सिंह and त्रिलोकी प्रसाद सिंह, they were given compensation. That was never challenged. वो भी हुआ है. So I have all along been the interested person in the eyes of the authority. Apart from that, as per the documents also, mutation is running in my name. मेरे नाम से जमाबंदी चल रहा है. Why should I not be interested person? Whereas their entire allegation or the claim is based on Annexure 2. हाथ से एक document बना दिया and even in the inquiry report it has come, they have not given any document. What claim they have? They don't have any claim. But I do have. I have got the documents. I have presented.
We are here to decide the title.
No, my lords.
Then-
That is what I am saying.
This is what he is saying. That when
My lords,
there
they
was
should
a
have
dispute-
some document in support before they come to the writ court.
We do not know. No support. You see, they have raised an objection. Once an objection is raised,
Yes.
then under such circumstances,
Section 11 inquiry was to be done by the collector.
okay,
Done it. A final order has already been passed. Where is the writ maintainable now even? और एक और चीज हम पढ़ दे रहे हैं. आपत्तिकर्ता द्वारा खतियानी रैयत के वंशज होने के संबंध में कोई कागज प्रस्तुत नहीं किया गया. पेज 16, fourth line from the bottom, my lord. Now they don't present a document there even in the inquiry. Only on the basis of frivolous claim, on the basis of their own handmade document, till the writ court they have approved. 11 में तो इंक्वायरी करना था कलेक्टर को, he did it. उसके बाद बोला है अवॉर्डी को उचित पहचान कर भुगतान करने का आदेश दिया जाता है. He has already passed an order finally. Now if they are aggrieved by this, they can well even challenge it. This can be put to challenge, but circle officer का inquiry report they have put to challenge, not the
this
final.
is an appealable order.
It is.
Under which provision?
Yes. 30 में ही refer.
Section 30 is the only, your lords, my learned friend, let
Just
him
a moment.
complete, I will reply.
This is an appealable order under which section?
It's section 30 only, my lords. It can be referred now. The award when it is final. but not the inquiry report of the
So
CEO.
for that purpose, they'll have to file a fresh application. under
Yes, well,
Section 30.
this can be challenged. It is an award, they can challenge it. Now it has attained finality.
So
they can challenge it.
your argument is that they raised an objection. The inquiry was done in terms of Section 11.
Yes,
An order has been passed.
yes,
And after settlement in terms of Section 11,
yes.
they have a remedy under Section 30, approach the authority and ask them to refer the dispute for adjudication by a confiscation.
Yes.
Right? कुछ और बोलना है आपको?
Section 12, my learned friend says that after inquiry under Section 11, then Section 12 award was prepared. Section 12 also says that it is subject to any objection to be raised and it is to be referred under Section 13.
That's right. So you go and file an
Therefore,
application under Section 30.
in the shape of objection, I have raised the objection
You see,
after
there
preparation
are
of
two
the award.
stages. There are two stages, Mr. Sani. One is that you raise an objection, and
After
then he
preparation of the award.
just a moment. When was the award prepared?
Yes, but my learned friend is referring. That
You
is
just-
after
just a
preparation of the
moment.
award.
You just tell us when was the award prepared?
Yes.
बताइए।
I may say 10/9/16 को award बना है. That is annexure in first paragraph itself.
Yes. Thereafter we raise the objection.
Just a moment. 10/9/2016
2016.
is the award,
Yes.
right? And after preparation of the award,
17/1/17 we raise the objection.
17/1/17
That is annexure 3. That is after preparation
raised
of the
objection.
Yes. And only remedy is Section 13. No other remedy.
Award is prepared under Section 12.
Yes. Final is Section 12. 11 is inquiry. Award of collector when to be final. Such award shall be filed in the collector's office and shall accept as hereinafter provided. That includes Section 13. The final and conclusive evidence as between the collector and the persons interested, whether they have respectively appeared before the collector or not, of this true area and value of the land, and the apportionment of the compensation
You see,
amongst the person interested.
In this particular case, if you dispute any date, please let us know.
Yes.
Award was prepared on 10/9/16, correct?
Yes.
Right? This award, preparation of award is preceded by any inquiry. Inquiry under Section 11 is preceded by preparation of final award. Once the final award is prepared, then if any objection is raised, final award is prepared after inquiry under Section 11, and if any objection is raised, then the matter has to be referred to civil court for adjudication under Section 30. There is no question of fresh inquiry
That
under
is my
Section 11. Isn't
Even
it?
the award is not before your lordship. Again, just a minute. The award
No,
itself.
date of the award
Yeah,
is
date-
there.
date of
There is
the
no
award is
doubt
there.
about the date of the award.
No, I'm
So
not
once
doubting
the award has become final, there is no question of any further inquiry. Then if there is any dispute raised, the matter has to be referred to the
These functions of
civil
the
court for adjudication. State, is this the procedure?
Yes, yes.
Once the final award is prepared, there is no question of fresh inquiry under Section 11. So the inquiry which has been made pursuant to their objection on 17/1/2017 is post preparation of final award.
Lords, I will
There
say
was
that.
no scope.
I will say that. Lords, the only thing is that plot number 53 जो खाता संख्या 53 है, वो ये बोल रहे हैं कि हमारा है. But that was not the matter of adjudication even. That is also covered.
Not the matter of adjudication.
Not the
Yes.
matter of acquisition even.
No, that is not correct.
Lords,
I have checked it. आप तो अभी तक ये सब point out ही नहीं किया. हम already check कर चुके. आप कुछ बताते हैं कहाँ से? You come to annexure 1. जो इनका टाइप कॉपी दिख रहा है उसी की बात है. ये देखिए पेज नंबर 19
Yeah.
153 में है 145 146 दोनों है ना?
Sorry. 160, 145F, 146.
है ना तीनों?
Yes.
तो ये तीनों है, ये इनके ऑब्जेक्शन में भी ये तीनों है। देखिए दिस इज 160 145 एंड 1 ये तीनों
Let's
you refer the dispute. Yes, state you refer the dispute
That is
to
the
whatever be the consequences.
Plus,
we do
Annexure
not know.
2, if I may say, Annexure 2 does not speak about the award and the challenge to the award.
That's
Annexure 2 में कहीं ये नहीं लिखा हुआ है they have put a challenge to the award.
right.
ऐसा नहीं लिखा हुआ है कि award was prepared on so and the award has been wrongly prepared.
Yes, it has been mentioned. We'll see that. Okay. WPC number 1608 of 2017. Heard the learned counsel for the parties. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the final award in the present case was prepared on 10/9/2016 and objection to the award was raised on 17/1/2017 by referring to the genealogy. He submits that the respondent number 3, instead of making a reference to the court in terms of section 30 of Land Acquisition Act 1894, has got an inquiry conducted through the circle officer who has practically decided the title between the parties. The learned counsel submits that such action on the part of the respondent number 3 is not in accordance with law. No, please don't take me. Such action on the part of the respondent number 3 is not in accordance with law. He submits that the respondent number 3 should have referred the matter for adjudication to competent court of civil jurisdiction and accordingly appropriate order be passed. The learned counsel appearing on behalf of the private respondent has submitted that the inquiry was conducted upon the application filed by the petitioner on 17/1/2017. The inquiry was conducted in terms of section 11 and the objection of the petitioner was rejected. There is no challenge to such rejection of objection. He submits that those orders have been brought on record by filing a counter affidavit by respondent number 5. He has submitted that under such circumstances, the petitioner is not entitled for any relief. The learned counsel appearing on behalf of the state has submitted that the award is finally prepared after required inquiry in terms of section 11 and as per the provisions of section 30 of Land Acquisition Act 1894. If any objection is filed, the matter is to be referred to the court in terms of section 30. He submits that the inquiry under section 11 is a stage prior to preparation of final award, correct? He has submitted that the final award has been prepared on 10/9/2016. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that final award in the present case was prepared on 10/9/2016 and objection to the final award was raised on 17/1/2017 by the writ petitioner. By referring to certain chronology, and a prayer was made before the respondent number 3 that the name, that the person in whose favor the award was prepared, his name should be deleted and appropriate amendments be made in the final award. The respondent number 3, instead of referring the matter for adjudication in terms of section 30 of Land Acquisition Act, has directed for further inquiry by the circle officer, who by inquiry report dated 28/1/2017 has opined that the award was rightly prepared, and it appears from the record, particularly the counter affidavit filed by respondent number 5, that the district land acquisition officer, respondent number 3, rejected the objection filed by the petitioner by accepting the report of the inquiry officer. This court is of the considered view that once the final award is prepared, after conducting all the required inquiries in terms of section 11, and the award is prepared finally in terms of section 12, as per the provisions of section 30 of Land Acquisition Act 1894, the dispute with regard to apportionment of any amount or entitlement with regard to any person is to be, it is for the collector who may refer the dispute to the decision of the court. In a case where the entitlement is disputed by referring to genealogy, such dispute could not have been decided through an inquiry by the circle officer, and consequently accepting the report of the circle officer, the authority should have referred the matter for adjudication in terms of section 30 of the Land Acquisition Act.
What has been defined under section 2D?
Consequently, the respondent number 3
Yes.
is directed to refer the dispute for adjudication by the competent court in terms of section 30. The needful be done within a period of 1 month from the date of receipt of the dispute. I think there is no dispute on that. Section 11, then section 12, and then section 30.
Yes. Yes. What has been defined under section 2D? madam?
अब वो civil court में.
Court माने designated court.
Authority item 16, WPC 7028 of 2017.
Where is the petitioner? This one. आप respondent है? You are the respondent?
Yeah.
Date of seizure जरा देखिए. You just let us know that is the criminal proceeding and confiscation proceeding are two separate proceedings, or they are interconnected?
They are both are two different proceedings. Confiscation case is running at the other part and criminal case is
Yes, let me put this question. Yes, petitioner. The confiscation case and the criminal case are two different proceedings, or they culminate into one proceeding? Two different proceedings, right? So the orders that you have placed before us, they are all subject matter of criminal.
In the court of procedure and confiscation proceeding has been initiated.
That's right. So they are two separate proceedings, correct?
It's departmental confiscation proceeding is the departmental proceeding
And they are absolutely independent of each other.
by the departmental officer, DFO.
They are absolutely
Yes.
independent of each other, correct?
Yes.
Now, therefore, the judgments which you have cited, these two judgments, right?
Yes, ma'am.
They are all subject matter of final adjudication in criminal case. So confiscation proceeding is a separate proceeding altogether, and the criminal case will have no bearing, isn't it? So your case CRNP 1638 of 2020, that was subject to the satisfaction of trial court. वो तो कुछ नहीं होगा, because that particular release is subject to final adjudication by the trial court. And then the WP Criminal 110 of 2021, this is again under Essential Commodities Act. This is also subject to trial court. Under the forest prosecution, case is different from seizure, and it is not subject to any criminal case, isn't it? We have also held it in one judgment that in fact even acquittal in a criminal case may have no bearing on the confiscation proceedings.
Yes, Lord.
So therefore, these two judgments which you have cited do not apply to the facts of this case. Absolutely they don't. Now you say that you had all the documents. Now you turn to your page number. You have annexed 2-3 documents. You turn to your page number 46. This is the document you are relying upon, correct? You are relying upon this document, you have annexed it.
Yes, Lord. Yes.
Just see at the top, what is the time of its generation? 12:45, after the seizure, correct? At the top, 12:45. This is the document created after the seizure.
No, Lord. Not after this.
Yes.
In the during daytime of the seizure and in the night time the seizure had been.
No, you see, this is created on 24/3/2014, 12:45.
Yes, Lord. And on the same night.
No, we do not. 12:45 is the time.
Yes.
Yes.
It is daytime and seizure had been done at the night time, 11:30.
Twenty-four 3 12:45 is the 11:30 p.m. This is 12:45 in the daytime. Yes? Look at the screen. हाँ बोलिए.
Yes, Lord. In this document, the time is of daytime, midday, 12:40.
देखिए सर.
The seizure had been on the same night, because the earlier invoice was created, and thereafter the 15 tons of the coal had been loaded. It takes time, and the truck after loading was departed from there from at 11:50 p.m. Lordships. It is in the page 45 Lordships, page 44 Lordships. Departure time is time out 11:15 p.m. And right after 50 minutes, the truck had been seized. And there is no possibility that in these 15 minutes, in the midway, 6 tons of coal can be loaded on it. Outing time of the truck is
This is loading advice,
Yes, yes.
road challan.
for 11:50 p.m.
This page number 44 is what time? 11:50 p.m.
Yes, sir. It departed. Time out at the Bay Bridge.
Where do I get that? Eleven fifteen p.m.
Lordship, in the offense report, it has been stated that the coal has been extracted from the Kordak forest. Report, it has been stated that that was the Balkaru forest. Driver was arrested, but their signature has not been taken on the way taken. Their signature has not been taken.
The seizure is not in dispute. You have not disputed the seizure.
Disputed Lordship, I have also filed in the supplementary affidavit that the seizure has not been enclosed with the prosecution report and sent to the court. Subsequently, it was brought in the proceeding of.
We are seeing your petition which was filed for release of the vehicle.
Weight, and in the weight scale, there is no signature of the arrested persons. That should have been Lordship.
No,
That
you
their
just
persons 20
you
persons
show
have
it
been
from your annexure 6. The chauffeurs filed before the confiscation case.
Yes, sir.
Yes. Just
In the para 8 Lordships, para 8, then it is pertinent to submit as per offence report the additional coal was illegally loaded from the Kordak forest area. But in the verification report mentioned that the additional coal was loaded from Bedkaro prohibited forest area and were meant
yes.
hypothetical my entire version of prosecution is based on idle conjectures. I have raised this issue there.
But at the same time, you say that you can't have it both ways. No, you are at the same time you are saying that you had the documents for the purposes of loading of the coal, and that coal was loaded to the extent of 15 point. How much is the figure?
15.6.
Actually, Lordship,
15.6.
the petitioner was having inimical term with some persons who was in conference with the forest officials seized his truck. Under deep conspiracy.
From where are you saying this? कहाँ से?
This point had not been raised at any level, but I had
Even in
inquired.
the writ petition there is no such point. Deep conspiracy का कहानी जो आप सुना, रिकॉर्ड से बाहर कुछ मत बोलिए. Deep conspiracy हम लिख नहीं पाएंगे.
Yes, yes, sir. Yes. और कॉन्फेशनल स्टेटमेंट में जो दोनों अरेस्टेड पर्संस का है बिल्कुल एकदम एग्जैक्टली सेम है. कॉमा फुल स्टॉप कोई भी एक वर्ड भी इधर से उठा नहीं. सप्लीमेंट्री काउंटर एफिडेविट में फाइल है वो कॉन्फेशनल स्टेटमेंट. और अगर 6 टन ज्यादा भी था तो ये मामला ओवरलोडिंग का हो रहा था.
डॉक्यूमेंट तो आपका उस समय नहीं था ना. The truck was not accompanied with the required documents.
हाँ लॉर्डशिप वो तो लिखी भी है, लेकिन अब ये लोग नहीं उसको कंसीडर किए. अधिकतर केसेस में इन लोगों के हैंड में ही होता है. हम लोगों के हैंड में तो कुछ होता नहीं है पिटिशनर के हैंड में. वो जो रिपोर्ट तैयार करे वही हो जाता है. हमने जो डॉक्यूमेंट्स 15.73 टन का जो दिया उसका उन लोगों ने वेरीफाई भी करवाया थोड़ी कॉलेज इमेज के, और वो वेरिफिकेशन रिपोर्ट भी लगा हुआ है. ये सही है, हमारे स्तर से रिलीज किया. और खुद फर्स्ट ऑर्डर कन्फिस्केशन में वो खुद ही दो बात इनका कॉन्ट्रडिक्टरी लिखते हैं. एक बार लिखते हैं कि ट्रक ओनर और एक व्यक्ति भाग गए, एक बार लिखते हैं अंदर में ही कि ट्रक ओनर और ड्राइवर भागने लगा. जबकि प्रोसिक्यूशन रिपोर्ट और ऑफेंस रिपोर्ट में ये चीज कहीं भी नहीं है कि ट्रक ओनर भी था या कोई व्यक्ति भागा भी था जब उसको इंटरसेप्ट किया गया. तो और 10 साल से ज्यादा वहां पर ट्रक तो ऐसे ही यूजलेस हो गया होगा, पड़ा हुआ है. जो भी कंडीशन इम्पोज किया जाता है सब हम मानते हैं लॉर्डशिप.
अब तो कंडीशन नहीं होगा ना, अब तो रिलीज होगा, क्योंकि अब तो कोई कंडीशन का कोई बात ही नहीं है. अब तो जो भी कुछ अगर आपका
लॉर्डशिप कोई भी कंडीशन,
क्या ही कंडीशन हम आपको लगा सकते हैं बताइए.
लेकर अगर रिलीज कर देते हैं तो हम कंडीशन मांगते हैं.
आपका शोकॉज कहाँ लगाए हैं आप?
सप्लीमेंट्री में लॉर्डशिप.
शोकॉज सब चीज सप्लीमेंट्री में ही लगाया करिए, ठीक है. मेन रिट पिटीशन में कुछ लगाने का जरूरत नहीं. एवरीथिंग इन सप्लीमेंट्री, राइट?
किया हुआ है. और देखिए
बताइए शोकॉज कहाँ है? वेयर इज द शोकॉज? बताइए शोकॉज वेयर इज इट? शो मी द शोकॉज.
18/6/2021 के एनेक्सर 6
Annexure 6.
ये सब केवल शोकेज के लिए फाइल किया गया था उसको लगा.
कहाँ ये?
एक ही सप्लीमेंट्री मेरे साइड से फाइल केवल एक.
शोकॉज रिप्लाई आप फाइल किए हैं, शोकॉज कहाँ है उनका?
शोकॉज ही है लॉर्डशिप, जो कि लोअर कोर्ट में फर्स्ट प्रोसीडिंग के टाइम में हमने वहां पर फाइल किया था.
अरे आपका रिप्लाई नहीं पूछ रहे हैं, उन्होंने आपको शोकॉज नोटिस दिया होगा ना.
वो शोकॉज नोटिस
कहाँ है?
जो उन्होंने किया.
हाँ
नहीं शोकॉज नोटिस नहीं दिया था हमको, सिर्फ वो उनके ऑर्डर शीट में ही है लॉर्डशिप, फर्स्ट ऑर्डर में ही है. इनको नोटिस दिया गया और सीजीएम को भी इन्फॉर्म किया गया.
अरे भाई आपके पास कोई शोकॉज का नोटिस आया होगा तब ना आप उसका जवाब शोकॉज फाइल किए होंगे.
यस लॉर्डशिप आया.
वो कहाँ है? I want to see that show cause. What is the tenure of that show cause? Tenure क्या है इसका? You have annexed it in your counter affidavit. Have you annexed it in your counter affidavit?
Show cause. No results.
Page 29 में एक स्वीकृति आदेश है लोग से. Page 29 of my petition. Confiscation proceeding चलाने के लिए स्वीकृति आदेश है. Page 29.
This is not show cause.
You come to page number 33. Serial number 4. Read it, please.
मैं क्या वाहन मालिक भारतीय वन अधिनियम 1927 संशोधित 1979 की धारा 52/5 में वर्णित तथ्यों के आलोक में किसी प्रकार का छूट ले सकते हैं? अभियोजन एवं विपक्षी द्वारा समर्पित तथ्यों के अवलोकन में स्पष्ट है कि जब गश्ती दल ने जब्त ट्रक को रोका तो गश्ती दल को देखकर वाहन मालिक एवं वाहन चालक वाहन छोड़कर भागने लगा। अगर वाहन मालिक की संलिप्तता वन अपराध में नहीं था तो उस गश्ती दल को देखकर भागना नहीं चाहिए था, अपितु नहीं रुककर गश्ती दल को सारे कागजात दिखाने चाहिए थे, लेकिन उसके द्वारा ऐसा नहीं किया गया। इससे स्पष्ट होता है कि वाहन मालिक की संलिप्तता वन अपराध में थी। चूंकि वाहन चालक वाहन मालिक का एजेंट होता है, इसलिए वाहन चालक द्वारा
आप उनको ये बताइए, you read 52/5. He has to prove that these people were acting without his connivance and knowledge, right?
Yes, Your Lordship.
But while deciding this point, you say that the owner of the truck was running away. Is this the prosecution's story?
Your Lordship, at that moment, 3 members were present: the cleaner, the driver, and the owner.
Show us from the prosecution. Page number 24 of the deputation. 24 perhaps, yes, it is 24. 24, 25, पढ़ी. 25 में है ना स्टोरी? पढ़ी.
सेवा में श्रीमान वन क्षेत्र पदाधिकारी वर्णी वन प्रक्षेत्र द्वारा श्रीमान वन परिसर पदाधिकारी बरकट्टा वन परिसर महाशय सादर सूचित करना है कि आज दिनांक 24/3/2014 को श्री गोपाल प्रसाद गुप्ता वन क्षेत्र पदाधिकारी बरी के नेतृत्व में उल्टे पन्ने नाम के गवाही के साथ गुप्त सूचना के आधार पर सामूहिक गश्ती करते समय देखा कि ट्रक नंबर 1610 चक्का गाड़ी पर अवैध पत्थर कोयला लगभग 22 टन लदा हुआ है। देखा ट्रक चालक एवं उपचालक को गिरफ्तार किया गया एवं कोयला संबंधित कागजात मांगा परंतु कोई कागजात नहीं दिया। चालक एवं उपचालक को पूछताछ कर नाम पता लिखा एवं गिरफ्तार व्यक्तियों को तथा अपराध प्रतिवेदन एवं जब्ती सूची घटनास्थल पर तैयार कर वन परिसर कार्यालय में समर्पित किया। यह ओरदारा वन क्षेत्र के निर्धारित माप के अंतर्गत लगभग
कहाँ लिखा है कि ओनर भाग गया?
in prosecution story it's not there but in the order sheet it's there. The revisional authority has
From where is he saying? He
Is-
cannot have a personal knowledge about all these things. He says that the owner of the vehicle ran away. Therefore, that order is perverse. 52(5) is a very important protection to the owner of the truck, that he does not know what his driver and cleaner are doing with the truck.
Lordship in page number
So
40.
therefore, this particular part of the order certainly cannot be sustained. And the way your deputy commissioner passes the order, have you seen your order? You have
Very
seen the order of the
easy.
deputy commissioner? Appellate order? One line order.
But in the revisional authority
What is the
additional-
basis of this? You have filed a detailed counter affidavit. Show us what is the basis for this, that the owner of the vehicle was running away from the spot.
it had come in the jabti सूची.
जब्ती सूची कहाँ है जब्ती सूची?
Page number 26.
Yes, 26 कहाँ है कि ओनर भाग गया? ओनर का साइन है? भाग गया, कुछ कहानी नहीं है.
It's written
You
there in
reconsider
God.
it. We don't find. You show me one material that he ran away from the school.
It's
Prosecution.
written here Farar. Politician.
फरार तो ऐसे आप लिखेंगे ना, because the owner is not present on the spot. Where is the prosecution story that he ran away from the spot?
As for the prosecution story, it's not.
It's not there.
If also the petitioner is relying on the documents, the matter
see-
can be remanded back to the revisional authority.
We will remand it back to the divisional authority. Ask him to verify the records and pass an order, because this particular part of the order appears to be perverse. Isn't it? 52(5) protection you have to consider. You can't ignore it. Fifty-two five का protection पर आपको hearing करनी है. That part is perverse.
Yes, Lordship, हमारे petition में भी वही है.
ठीक.
Lordship, may I please? In the impugn order, page number 42, the revisional authority has written here that it is correct that the order of the DFO says that the owner ran away when the truck was seized. However, both the offence report of March 24, 2014, the report of May 18 mention the owner as Farar, which though not fully clear could possibly mean the same thing. More importantly, even if the owner was not present on the truck when it was seized, in view of what has been stated in response to the argument of paragraph 1 above, the confiscation decision could not be effected.
No,
Finally-
you see, 52(5) has to be taken into consideration.
Has to be.
While dealing with 52(5), this is your finding in the entire order. Right? 52(5) you have seen 52(5). Have a look at that. No, for this 52(5) 252.5 is particular. I think it is Bihar Amendment. Is it Bihar Amendment?
Yes, boss.
May I read it? No order of confiscation under subsection 3 of any tools, arms, boats, vehicles, ropes, chains, or any other article other than the forest produce seized shall be made if any person referred to in clause B of subsection 4 proves to the satisfaction of authorized officer that any such tools, arms, boats, ropes, chains, or other articles were used without his knowledge or convenience, or, as the case may be, without the knowledge or convenience of a servant or agent, and that all reasonable and necessary precautions had been taken against use of the objects aforesaid for commission of forest offence.
That's right. So 52.5, for the purposes of 52.5, you record that he was running away. That is the only finding, isn't it? You have to see what defense he has taken in the application filed for release. What was his stand? Whether he has taken any stand that it was without his knowledge or without his connivance. Has he taken any such stand in the application filed under section for the release of the truck?
It has to be seen on the documents which they have relied on. The documents are not here. That's what. There is one judgment in the Supreme Court. To be verified, it's on Madhya Pradesh Forest Act, Amendment 52A, paragraph 24.
These are two distinct proceedings. There is no doubt on that.
And the same has been decided by.
We will only remand the matter with respect to 52.5. Search and seizure, the seizure otherwise is not in dispute. Only with respect to 52.5, whether he has given any such explanation and whether he has given cogent reason that he has no knowledge of it. Right? WPC number 7028 of 2017 heard the learned counsel appearing on behalf of the parties. District petition has been filed for the following relief. The learned counsel for the petitioner by challenging the order by challenging the impugned orders has submitted that the background of the seizure has been mentioned in the offence report and seizure list. It submits that the narration as is reflected from page 25 of the petition, which is a part of the offence report, does not reveal that the petitioner, being the owner of the vehicle, was present along with the vehicle. He submits that the report reveals that the driver and the helper they ran away upon seeing the authorities. He submits that the appellate authority has passed a cryptic order while dismissing the appeal against the order of confiscation. And so far as the revision authority is concerned, he has considered the provisions of section 52 within bracket 5 of Indian Forest Act 1927 along with Bihar Amendment and has recorded that the petitioner, being the owner of the vehicle, also ran away from the spot and therefore he is not entitled for protection under section 52. The learned counsel submits that the prosecution, the offence report, the narration of the offence report does not reflect that the petitioner was present when the vehicle was apprehended, and accordingly the authority has committed error of record by recording that the petitioner had fled away at the time of seizure of the vehicle. He has also submitted that as per the case of the respondents, the vehicle was carrying additional 6.320 metric ton of coal, and they had the document to carry only 15.730 metric ton.
At that,
He has submitted that necessary inquiry was also done from CCL and it was confirmed that 15.730 metric ton was loaded on the truck. But as per the case, it was found to be 22 metric ton. The learned counsel submits that otherwise also the petitioner was entitled for consideration of his plea in terms of section 52 within bracket 5 of the Indian Forest Act read with Bihar Amendment. The learned counsel appearing on behalf of the state has opposed the prayer and has submitted that at the time of seizure of truck, no documents were produced. Rather, the persons who were present in the truck ran away and the petitioner was shown to be absconded at page number 24 of the writ petition, though at page number 25 it has not been mentioned that the owner of the vehicle also ran away. Right?
as per the prosecution statement.
The learned counsel submits that in case the aforesaid plea of the petitioner is to be reconsidered, the matter may be remitted to the revisional authority. He has further submitted that
Revision authority come additional chief secretary forest environment.
revision
Revision authority come additional chief secretary forest environment and climate change department.
additional chief secretary. No, respondent number कौन होगा? The revisional authority come additional chief secretary forest environment and climate change department of government Jharkhand, state of Jharkhand. After hearing the learned counsel for the parties, this court finds that it is not in dispute that the petitioner is the owner of the vehicle, and it is alleged that the vehicle was seized with 22-ton coal and as per the order of confiscation, which was passed after conducting inquiry, the CCL had confirmed loading of 15.730 metric ton and upon payment it was found to be loaded excess to the extent of 6.320 metric ton. The confiscating authority, while dealing with the provision of section 52(5) of Indian Forest Act read with Bihar Amendment, has observed that the petitioner was found running away, leaving the truck along with the owner of the along with the driver. Although as per the offence report, there is allegation that two persons ran away, namely Latif Ansari and Jani Babu. क्या नाम है दूसरे का?
Yes.
Yes, and Jani Babu. They were arrested on the spot.
Yes, please.
Were
Yes,
arrested
yes.
on the spot, and as per the description of the offence, there is no mention about running away of the owner of the vehicle. This court finds that this aspect of the matter has not been properly considered by the confiscating authority, and so far as the appellate authority is concerned, he has also passed a cryptic order dismissing the appeal by the order dated 14/2/2017. The revisional authority also has not considered this aspect of the matter. Section 52 within bracket 5 of the Indian Forest Act, Red Bihar Amendment is quoted as under. This court is of the considered view that Section 52 within bracket 5 Bihar Amendment is an important protection for those whose vehicles are used for commission of forest offence without their knowledge or connivance. And that all reasonable and necessary precautions were taken against the use of the vehicle for commission of forest offence. The confiscating authority having recorded that the petitioner, being the owner of the vehicle, also ran away from the spot, and therefore his involvement in the commission of offence cannot be ruled out, is apparently an error of record, and consequently this aspect of the matter was required to be considered by the appellate authority / judicial authority, but the same has not been considered in accordance with law. Consequently, the matter is remitted back to the judicial authority for passing fresh order in the light of the provisions of section 52 within bracket 5 of Indian Forest Act, Red Bihar Amendment, without being prejudiced by the, after verifying the records, the plea taken by the writ petitioner before the confiscating authority and other plea which might have been raised by the petitioner before the authorities, and pass appropriate order within a period of 1 month from the date of appearance of the petitioner before the state authority. The petitioner shall appear before the state authority on 28 अक्टूबर को appear हो जाएगी,
Yes, sir.
on 28th of October. The impugned order of the judicial authority is set aside for the purposes of passing fresh orders.
Item 20, LOPR 2079 of 2018.
Yes.
This matter may take some time. And tomorrow, unfortunately, I am in a festival. Because
When do you want to do it? Next Monday?
any date,
25 you are there?
is there. You can do it next Monday.
Yes, you want to do it next Monday. Records have come. Records are required, not required. It is 25 only. So what is the contour?
25 feet, 25, it will take some time.
The learned counsel for the parties are present. With the consent of the counsel for the parties, both this case and the hearing for final disposal on Monday next. The records have already been received to be taken up at 2:15.
Sir, I have one request. Tomorrow when Nikhil is coming for final disposal, I will be absent tomorrow. If a prayer is made at Because I know your
Which
lordship
item
will
is that?
devote time for
Which
reading it.
item?
Tomorrow.
You have informed the other side?
I'll inform right now. Final disposal with is only one. Item 11.
ठीक है। कब चाहिए मंडे को?
नहीं जब बोले
नेक्स्ट ट्यूसडे कॉरेस्पॉन्डिंग
कल नहीं परसों भी कर दे सकते हैं।
परसों भी कर सकते हैं। ठीक है, अदर साइड से
अदर साइड को फाइनल डिस्पोजल के लिए रखा है। सो नॉट टुडे भी हो या फिर पास ओवर फॉर द डे या नॉट टुडे करेंगे
ठीक।
तो वेडनेसडे को कर लेंगे।
लेबर मैटर।
हाँ लेबर मैटर।
Item 21 WPC 2306 of 2018.
Yes, petitioner. Where is the petitioner?
Yes, in serial number 21. I'm praying for withdrawal of motion.
WPC number 2306 of 2018. MS. Your name?
Priyasha.
MS Priyasha, advocate, under the instructions of Mr. Ashutosh Anand, advocate on record, seeks permission to withdraw this writ petition. Accordingly, this writ petition is dismissed as withdrawn. Where court कर देंगे? Also for the status present. You have to put your signature with your enrollment number.
Item 22 WPC 2876 of 2018.
Yes, petitioner. Who is for the petitioner in this case? This is National Highway?
Yes.
Yes, what is it?
But also the petitioner is demanding compensation to us.
In terms of new act.
No. It's the old act, NH Act, you know, see?
Yes.
National Highway Act, you know, see? And our stand is that the land is already transferred by the state government after paying 10 lakhs, you know, see, to the state government, and that land was Gan Majubal land, and that was transferred to.
So there is a dispute between the state and regarding title.
Yes.
So what is the remedy?
Remedy is 3H4, you know, see,
Yes.
under National Highway.
You base that order? They can still invoke that?
Yes, you know, see. Because that street was with the NHI, you know, see.
Get me one or two orders. We have passed a number
Yes,
of orders.
yes,
I have
you
forgotten
know.
now.
Yes,
Right? So I'm just posting it tomorrow. They
Yes.
come tomorrow.
Yes.
WPC number 2876 of 2018. Nobody appears on behalf of the petitioner. Post this case tomorrow. Counsel for the State and National Highway Authority are present. Please mail one or two orders.
Yes, you know.
Right? Mail it to us.
Item 23 WPC 4321 of 2018.
Your Ladyship, this file was being managed by some other officers, and we have received this file very recently, Your Ladyship. So, if any other time after Diwali may be given to construe
Who
this.
are you?
Your Ladyship, I am the junior counsel for Sumit Garu, Your Ladyship.
So what do you want? What time? You have filed your fresh wakalatnama?
Your Ladyship, yes, Your Ladyship.
You have filed your fresh wakalatnama?
Yes, Your Ladyship. The senior has instructed me to just take some time to construe the file properly, Your Ladyship, after Diwali. if any time may be given in addition.
Your name, please.
Your addition is Nilohit Chaube, your addition.
Sorry?
Nilohit.
Nirlohit Chaube.
Yes, your addition.
Junior counsel to Mr. Sumit Garg
Yes, your addition.
has submitted that the file has been transferred to their office and they are yet to file fresh wakalatnama in this
No, no,
case.
no.
When do you want?
Should any date after Diwali, your addition.
He submits that the matter be posted after Diwali and on that day he shall not see any adjournment. You are for whom?
And for the respondents to your edition.
The learned counsel for the respondent, MS.
Aprajita Sinha.
Aprajita Sinha, junior counsel to Mr. A.K. Das
Yes.
is present. Pleadings are otherwise complete?
Yes.
She submits that the pleadings are otherwise complete. After Diwali you want?
Yes, your addition.
बताइए कौन सा दिन? 18?
So, your addition.
उस दिन टाइम मत मांगिएगा हम देंगे नहीं. Post this case for final disposal on the 18th. In the meantime, the parties to file their necessary, their synopsis, list of dates, and the judgments which they seek to rely upon,
Congratulations.
much prior to the next date.
Section 24, WPL 4980 of 2018.
Yes, petitioner. Where is the petitioner? Yes. क्या matter?
Madam Petitioner challenged his punishment of discharge from service without affecting his superannuation benefit on the ground that disciplinary proceeding was not conducted in a fair and proper manner. And there was a preliminary objection in the reference case which was decided against him way back in 2011. That was not challenged initially. And when the final award was passed, during the pendency of the award, the workman died, which was known to the wife who is petitioner hearing. She stated that she died during the pendency of the reference case. No substitution was allowed to be was made out, madam, and the wife is challenging the award with additional prayer of claiming compassionate appointment, madam. Since the original.
That is why petitioner is absent. Nobody appears for the petitioner. Counsel for the state, counsel for the respondent is present. Close this case for tomorrow. कल उनको खबर कर देती हूँ. Mr. Kalyan.
On 29th of August, a scanned copy of LCR was called for. Scanned, I have gone through the file, madam. It is running into 150 pages. I may be permitted to have an access of the LCR by
हाँ yes.
soft copy.
कल 2:15 बजे.
Soft copy में
वो हम लोग नहीं दे सकते.
I will obtain it at my cost, madam.
नहीं
Since I have to
नहीं
refer
नहीं.
some
We are see, this is not the solitary case. You can have a look at the record.
I have
अभी
seen
से
that.
भी देख लिया है ना तो बस ठीक. ऐसे हम लोग नहीं दे सकते हैं. LCR का आपको इस तरह से नहीं दे सकते. नहीं तो जो देने वाला चीज तो दे ही देते हैं. कल 2:15 बजे. सुबह आप देख लीजिए. And inform Mr. Kalyan.